A Trump-appointed judge is clobbering Trump's DOJ for committing a fraud upon the court, in essence, lying to the court over and over again, using trickery, chicanery. And we're seeing this now take place across the country with Trump judges, Obama judges, of course, and Biden judges, as well as Ronald Reagan appointed judges still, George H.W. Bush, George W. Bush judges, and others. I mean, they're out there just saying, we have zero trust in this Trump DOJ. And every time we give you an inch, you try to take the whole thing. And do you think we're stupid? So you have this federal judge, young guy by the name of Judge Dudek, who's appointed by Donald Trump. He's recounting the series of events taking place in a case involving a habeas petition and an immigration proceeding. We've seen a lot of these, right, where Donald Trump's lost like 10 to 15,000 cases like this. His winning ratio in these cases is like, I don't know, like 5 to 10% at this point. It's that low. And the Trump regime just keeps on getting called out. I'll show you another case too, where a federal judge is basically saying, put this, we don't trust you. Put it in writing or shut the heck up. So here's what this Trump appointed judge talks about. It's a case involving a petitioner by the name of Dmitry Istrabov, a non-citizen sitting in immigration detention. Last month, this court ordered the government provide him with an individualized bond hearing. This was after the government conceded they were wrong for not giving him a bond hearing. Okay. And then the judge goes, what happened next borders on the surreal. 5 days later, an immigration judge refused to hold the ordered hearing, claiming Istrabov is not covered by the statute and thus ineligible for bond. Instead of defending this court's mandate, the government's counsel acquiesced in that refusal and waived any administrative appeal. Now faced with a renewed habeas petition, the government casually announces that its previous concession was in error and asked this court to reverse itself and hold that Istrabov is instead subject to mandatory detention. The government was right the first time, and its request for a do-over here is not just legally unsupportable, it is a masterclass in litigation cynicism. A federal court is not a testing lab where the executive branch can pilot a concession to get a case closed, stand by silently while its own administrative process flouts the resulting mandate, and then stroll back in demanding a clean slate. Give me a break. Why Istrabov is legally entitled to a bond hearing is a question this court has already answered in painstaking detail, an explanation that should not have required a sequel. And because the government has showed that it cannot follow this court's explicit directions and offers zero assurance that it will comply with the statutory process it previously championed, Istrabov will be immediately released. Accordingly, the renewed petition for writ of habeas is granted. Istrabov is entitled to a bond hearing. But because the government has shown a complete inability to follow judicial directions, the only remedy that law and justice require is immediate release. The government is directed, release Istrabov within 48 hours of this order. Respondent shall facilitate his transportation from a detention facility by notifying his counsel when and where he can be collected. The clerk is directed to terminate any pending motion and deadlines, enter judgment, and close the case. In other words, the judge was saying what we previously ordered you to do was go back and give the administrative hearing before an administrative judge. You then worked with the administrative judge, did not tell that judge what we ordered, allowed that judge, and by the way, a lot of these administrative judges are being just hired by the Trump regime. You didn't tell him, so that administrative judge made an order different than what this court directed that administrative judge to do. And so now Istrabov, through his lawyer, had to bring it to my attention again. And that's why the judge says it borders on the surreal that you're coming back for a sequel and acting like I'm not a federal judge. You're acting like you did some trick and like, gotcha, federal judge, like I'm supposed to be your friend because I'm a Trump appointed judge. And notice what the federal judge also had to put in the order, very specifically the instructions of when this individual gets released, where they go, how the lawyer has to be notified, because in the past, the Trump regime, and this judge knows this, would just basically throw people out without their cell phones, without telling their lawyers. And we've seen people die because they've been thrown out in conditions. Sometimes, we're in the summer now, but we've seen situations in the East Coast during the winter where people were killed because they're just thrown out there without their cell phones and they were freezing to death. So you have that. And then this just kind of reminds me as well of the case out of the Eastern District of Virginia, not a Trump appointed judge, but Judge Brinkema, who's a federal judge, Eastern District of Virginia, in the case involving Donald Trump's $1.8 billion slush fund for insurrectionists that Trump's DOJ and others in the House of Representatives are saying this slush fund no longer exists. We're not using the slush fund anymore. So as we predicted here on the MeidasTouch Network, and as I predicted with Harry Litman and Michael Pope, I said the judge is going to say, okay, put it in writing or else I'm going to issue an order. And so there was this incredible moment bordering on the surreal, to borrowing a line from Judge Dudek, where Judge Brinkema speaking to this DOJ lawyer and saying, you agree with me that your position is that the slush fund doesn't exist, right? Right. Okay, so why don't you put that in writing in a stipulation signed under penalty of perjury? Because why aren't you doing that? I don't know. And Judge Brinkema's like, you don't know? Kind of a high profile case. Don't you think that when you step into my court, you should know? Because your argument why I should dismiss this case is that the case is moot because you agree not to have the fund, but you don't want to put that in writing. Like, are you trying to do like a trick, like a gotcha? Are you using the federal court as some like laboratory and testing ground versus what a federal court's supposed to be? I want to bring in Harry Litman from Talking Feds. He had the Talking Feds YouTube channel, Substack, and podcast. Harry, it's great to see you.
Likewise.
Bordering on the surreal because the DOJ can't follow basic judicial directions. We've seen this now in quite literally tens of thousands of orders now. And we and I have been covering them. What a humiliation ritual. I mean, it reminds me of some of these lawyers I remember when I would go into state court, who would be like disciplined lawyers on probation. And you would see them, they'd always show up and the judge would be like, all right, I got to deal with you again. And you'd be sitting back there watching the lawyer lie to the judge and you'd be like, oh, how humiliating. That's the DOJ where you used to work, Harry.
Give me a break. Those are not words you normally see a federal judge put in an order. Surreal. And then give me a break. First, you're totally right, Ben. This is this recurring issue that either some combination of DHS recalcitrance or just complete administration-wide indifference to the rule of law, they have done tens of thousands of times. It's the same issue here. It is when someone has been in the country for a while and they're picked up, that has always meant that there's a provision, 1226, that says they can move for habeas corpus and get a bond hearing. Do you get released or not? But the administration's been trying and not taking no for an answer to say, these people who are in the country, they are applicants for admission, same as if they were first presenting themselves at the border, even though they've been here for decades, maybe having lives. That's the position that they really are just completely bullheaded about trying to effectuate. And you can see why. If they can have that position, then there's none of this business or worry about being in front of a judge. You just stick these guys right away in a detention center and they never see the light of day again until South Sudan or wherever they bring them. So it's a really recurrent refrain and a lawlessness that they won't go there. But then, yes, the second one I want to underscore that you said is this administrative law judge. Sounds like a judge, starts with a J, but these are just appointees of the Department of Homeland Security. So they're the people who are in the chain of command, basically. A federal court, a neutral federal court, and we're talking about a Trump appointee, as you said, said painstakingly, along with, I think it's well over 90% of all the district courts who have looked at this, said this is not an applicant for admission. Therefore, we just give them the possibility of just a hearing as you would for a prisoner, just to possibly be out while they await the process that DHS wants to put them through. And that's what they are trying to prevent. So this is really, the whole borders on the surreal, give me a break, really illustrates just how completely putting their, thumbing their nose at the rule of law this is. Something's really interesting about what he did here, and I don't know if it will hold up, because he said, just you did it wrong, therefore I'm granting and freeing the guy. And if they can well say, well, what if you were a dangerous guy, etc.? You didn't even go through that inquiry. The judge has a good reason. I didn't go through the inquiry because you totally twisted and deformed what I said, and that's the way it goes. That'll be a possible thing they could do on appeal. But I wanted to set that up because contrast that with Brinkema, who, as you said today, Todd Blanche says in the House committee, we're not going forward, won't even put it in writing. And this is, remember, it's a settlement agreement, if that was their position. That's a contract. That's a deal. And supposedly, Trump gave them the settlement of his case, which, of course, is a unconstitutional and meritless case. So he gave them exactly zero. But then they gave him this fund. It's not to them to now say, well, we're not gonna give it, gonna go forward. But at a minimum, they got to say, something that a court can hold on to. And for Brinkema to say it's not enough to just have these words that Blanche says, not even in writing, not even under oath in the House, that really is give me a break. But now it's pretty interesting. And first of all, let's say they try to appeal. What the hell are they going to say? Emergency, emergency. She's put a hold on this fund, which we ourselves want to put a hold on. What's the irreparable injury? What's the problem that they would have to seek emergency relief? But then she's really called for the signature. This is like, bring me the head of the top dog. She wants Stan Woodward, who signed the settlement agreement, and Scott Bessent, the Treasury Secretary, and Todd Blanche to sign things under penalty of perjury. They're going to try to wriggle out of that, you can be sure. But Brinkema could try to insist and say, look, I'll tell you this fund is going nowhere unless you do it. But it's an odd position because they're saying we want the fund to go nowhere. Anyway, we've got this total confluence of the situations where the administration wants to ignore the law, ignore the facts, even in the slush fund, and judges now, really have them backed up against a corner. So it's a tough position for them to try to come in and swear their way out. It's even worse. I don't know if we'll talk about this. Maybe next week, Judge Williams has said, did you commit fraud on me or not? Donald Trump's lawyers have to answer that today. But it's a rebuke, right? It's really to say, I know you said that, but we don't that's not good enough. Legally, it's not good enough to do a whole rescission of a settlement, but it's really insulting Blanche, who, remember, he was asked, will you put it in writing? And in his very sort of chest-thumping, Trumpian, bellicose way said, no, that's all you need to know. And Judge Brinkema said, that's not all we need to know. Not with you, Mr. Blanche. So that's a solid rebuke, and it's well-deserved.
Everybody, make sure you subscribe to Harry Litman's YouTube channel. It's called Talking Feds. Just search right now on YouTube, Talking Feds. Subscribe right now. Thanks, Harry.
Thank you, Ben.
And everybody hit subscribe here.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.